Any mention?
Yes,
Please, Your Lordship, I beg to make a mention on part 2 of the hearing list, item number 13, the Junjunwala, Your Lordship.
who is the other side?
Lordship.
You're opposing?
No, Your Lordship.
Yes.
After 2 weeks, Your Lordship.
You are for the respondent, is it?
Yes, Your Lordship.
Yes, so the request meet. And we have the respondent. This is met after 2 weeks. Yes.
I will pledge, Your Lordship.
Please, Your Lordship.
Yes.
I beg to mention item number 16, the hearing list, my lord. Just praying for a week's time, my lord. My friends have no objection.
No objection, Your Lordship.
Request by petitioner. Yes.
Much obliged.
Item 16.
Yes, my lord.
16, Your Lordship.
Mr. T.T. Diengo is there.
Yes, my lord. I have spoken to him also, my lord. He also has no objection.
You are for the respondent.
My lord, I am for the petitioner in the miss case, my lord. I filed an application for impleadment. All the matters have been fixed together for hearing.
Impleadment revision application.
In the revision application, my lord.
Okay. Consider it.
Obliged.
May it please, Your Lordship, I beg to make a mention of item number 2, Your Lordship.
Yes.
Lordship, I'm praying this matter may be listed after 2 weeks, Lordship.
Yes, sir. The request of the petitioner and not being objected to by the respondent. This is met after 2 weeks. Yes.
Lordship, similar prayer for item number 3, Lordship.
Yes. Same order.
Similar prayer for item number 4, Lordship.
Item 4 also.
Lordship.
Who is there? No problem.
No objection.
Same.
Lordship, here for respondent number
4, 5 also.
Lordship.
All same order. Anything more? You have rejoined, Mr. Karwala.
Possible appear for 5, item 5.
Yes.
Highly obliged.
May I please, Lordship? I beg to mention item number 8.
Yes.
May this matter take up after 2 weeks, Lordship?
You are making a mention on behalf of the
Mr. SSA, petitioner.
No objection, Your Lordship. I'm appearing for the sole respondent, Your Lordship.
yes, the request made on the petitioner. This is met after 2 weeks. Yes.
Much obliged.
Please, Your Lordship. Lordship, I beg to mention item number 6.
Yes.
Pray for 2 weeks' time, Your Lordship.
You were there.
Yes, lordship.
This matter can be taken up by this court. Can it be?
Lordship, I think so. Your Lordship was.
They're in on behalf of the state.
Isn't it?
Yes.
Yes, Lordship.
Mr. Karwan, you do not
Yes.
remember this court.
Lordship, you were there at council.
Just say. This is before matter before any other bench. Yes.
Obliged.
Within bracket you write.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 17.
17. Yes.
Your Lordship, I beg for 2 weeks' time.
You are appearing for the appellant.
Yes, Your Lordship.
He's in custody. He's in custody. He's in prison.
Yes, Your Lordship.
Definitely there will be no objection.
No objection, Lordship.
Yes, sir. The request made on behalf of the appellant. This is matter after 2 weeks. Yes.
Much obliged, Lordship. May I please, Your Lordship? I like to mention item number 20, Your Lordship.
Yes.
A prayer for 2 weeks' time, Your Lordship.
You are appearing for making a request on behalf of?
On behalf of the petitioner, Your Lordship. As a standing counsel, he is unable to attend because of the death of his uncle.
We have no objection.
At the request of the petitioner, list of 2 weeks. Yes.
Please, Your Lordship, I beg to mention item number 12, Your Lordship. Lordship, I kindly pray for 3 weeks' time, Your Lordship, in this matter.
We have no objection.
This is also at the request of the petitioner, list of 2 weeks.
Much obliged, Your Lordship.
Lordship. Item number 10. After 3 weeks.
Yes, Mr. Sangha.
My Lord, item number 10. Yesterday we tried to ascertain the convenience of the learned CJC, but he has given the impression that he is ready, so we have thoroughly prepared the case. Now he is adjourning the matter.
No, this is something not very fair, Mr. Devnath.
I tried to ascertain. He should have informed me. Anyway.
This is very unfair. If you give an indication to the other side that you will be taking up a matter today, then asking a time later, that is
Lordship,
not,
in this matter,
this court doesn't appreciate those kind of things.
Lordship,
Because on the other side for many years, that is not something very appreciable.
Here, if there's interested, then actually in this matters, that the DSG is supposed to appear, Lordship. I
It's
didn't
okay,
get
then
him.
you could have informed me.
So,
You
Lordship,
have
I was not
See,
having.
we do not expect a senior counsel to be saying something which is not correct.
So,
We
Lordship,
take his statement.
main party is there, Mr. Synchrony is there. So, if it is they are ready, so Lordship, that will be. I'm not hearing. If they are ready, then Lordship, all right.
We'll take up. All right.
Item number 1.
Nobody for the petitioner?
No, Lordship.
Yes, you are there, Mr. Jha.
Sorry, my lord.
You are there in this case?
Item 7, my lord.
Yes.
Yes, ma'am. My lord, this is concerning the promotion, my lord. Petitioner is claiming the promotion, my lord,
Yes.
from the date when the juniors has been promoted, my
You have been superseded
lord. My
and you have made them party.
lord. My lord.
You are seeking restoration of seniority also.
My lord.
So, ready?
Lordship, learned DSCI is on decks.
So, what is to be done? You want this court to wait for him?
We'll have the matter after 2 weeks.
Without, my
You
lord.
have to make some arrangement. Talk with Dr. Majika. Things cannot go this way. There are other central government councils also. If he alone cannot manage, then there has to be somebody. Convey to him. Yes, the request made on behalf of this, on behalf of Dr. and Majika Lanet, DSGI representing the respondents. This is matter of 2 weeks. Please see, cannot keep on, see, like if parties are ready, then just non-availability because he is engaged in other court, no ground for adjournment. Yes.
Obliged, Lordship.
Item number 9.
Yes.
May it please your lordship, Mr. Sen is on sanction leave. May this matter be taken up after 2 weeks?
Mr. Shen.
Yes, your lordship.
Which Shen?
Mr. Subir Sen.
Subir Shen. He's on leave.
Yes, your lordship.
He's out of station.
Yes, your lordship.
Lordship, no objection. I thought they will mention Lordship since sir is
Yes.
on leave.
Lordship, may the interim order continue?
See,
till
like
the next
whenever in cases wherever you have intention to take time or you have difficulty like this, you should inform the others.
Yes, your lordship.
Because they will not waste their time.
Yes, your lordship.
Yes. Just say the request. You are also advocate on record here in this case.
No, your lordship.
At the request made on behalf of Mr. S. N, who is stated to be out of station. This is matter after 2 weeks.
Obliged, your lordship.
Item number 10.
My lord, this matter relates to the grievance of denial of 7-pay commission benefits to the petitioners here. They are the teachers and the non-teaching staff in the Assam Rifle Public School Light Corps. Now, my lord, the brief fact, my lord, here the school is run by the society, Assam Rifle Welfare Society.
Who is representing the other side? Who is the respondent?
My friend Mr. Sinkon is appearing for the school.
So, you are ready?
Yes, your lordship, he's on.
Yes. You are both of you are there. Say.
Yeah, together.
How many respondents are there?
My lord, the respondents. Five respondents are there.
All are represented?
All are represented, my lord. 1 to 2 is represented by the CJSC. Remaining are represented.
That is the matter which Mr. Jagannath was mentioning just now.
Yeah, just now.
So where he has disappeared then?
Just
so he is the main respondent.
He is one of the main respondents.
Now implementation of the recommendation of 7th Pay Commission.
Yes.
To the Assam Rifle Public School.
Yes. Now this is the
Can
issue.
it be right? See, ARPS otherwise is not under Union government, isn't it?
Yes.
It is not under the Ministry of Defence also. It is run by Welfare Society. Yes.
Correct. Now what happened, the service rules during the advertisement also, they put up the advertisement that the salary and allowances will be as per the state government or the central government. On that basis, advertisement floated, petitioners participate in the selection process, induct in the service, continue, and they used to pay that one. Now, earlier they denied 6 pay commission benefits. So matter came to earlier as well go the High
On
Court.
earlier occasion,
Yes.
have they adopted
Yes,
all
yes,
those pay competition?
Yes.
So was implemented.
Yes, they denied 6 pay commission. Therefore, they came before the as well go the High Court. Court had learned a single bench dismissed the petition, saying that it is not maintainable. It is school run by the society only. So matter traveled to division bench. Division bench has nullified the single bench judgment and entertained the petition and granted the relief, directing the school and the authorities to implement the 6 pay commission.
There is no further challenge.
And they challenged for the Supreme Court. Supreme Court dismissed them. And they came back here, they implemented, and after implemented the 6 pay benefits, they attempted to shut down the school, close down the school, saying that since we implement the High Court and Supreme Court order, we don't have any more fund to run the school. So they was made to shut down the school. Petitioners were compelled to come to this honorable court again against the closing down order. Matter came up, and ultimately there was a discussion between the parties, and the petitioner also gave up some benefits of the 6 pay commission also, the benefits also, and there was an amicable settlement.
So that will be like the understanding.
Yes.
Between employer and employee.
Yes.
That is something beyond the Supreme Court judgment, the division bench judgment.
Yes. Now what happened there? They filed after they reached that some understanding to save the school from shutting down, closing down. The DG, Director General, who is the head of the institution, has filed it before this court, saying that the service condition of the existing employees cannot be altered, changed in view of the decision of the High Court and Supreme Court. Now that issue is then finally the right of the petitioner, whether they entitled the benefit of the central government pay scale or the CPC recommendation. DG himself said that is then its finality, we will not alter it. So on that basis, he filed the petition. This honorable court recorded the affidavit and closed the petition. Smoothly running the school is running it, and subsequently, my lord, the 7 pay commission benefit also come. So petitioner claimed that in view of the 7 pay commission, kindly.
But the thing is that, say, supposing if there is a financial crisis, then how the order passed by this court will be implemented? Now, Mr. Shangri, you do not know, but then there appears what from your submission that there is a judicial pronouncement with regard to the implementation of the pay commission recommendation. Now, it appears that if supposing if pay commission recommendation is not accepted by the government, then what happens? It becomes a binding on the school authority to accept it.
No, my lord. Whatever CPC recommendation is taken accepted by the central government, my lord, that will be required to be implemented.
So it means if it is not accepted by the central government,
yes,
there will be no binding on the part of the school.
Yes.
But then moment it is accepted by the central government, so it means it has to follow whatever the central government does.
Exactly.
Now, what happens if the school doesn't have fund then?
My lord, therefore that issue came up in 2017-18. They take the plea that we granted the CPC benefits. Now the coffer of the school is already empty, so we have no more fund to run. That issue came up, and there was an amicable settlement.
Some issue can be amicably settled.
But
throw some more light. If there is a fund issue, then how that will be amicably settled?
My lord, what happened in that case? They closed down the school, and there was an intervention by this honorable court. The closure order was stayed by this honorable court, and during that process, the DG has granted 2 crore something to revive the school. And they urged the petitioner, the staff, you give up some benefits like a house rent, the student fees, tuition fees. So there was a sitting together, and the teachers and the non-teaching staff also okay. We appreciate the difficulties of the school financial position, so we can give up to certain limits, Like for example, they entitle 6 CPC, so they waive 2 years. 3 years. Some items on remaining the right of the.
What bearing this settlement would have on the orders of the division bench of the Guwahati High Court, which was upheld by the Supreme Court?
Therefore, with regard to the rights of the petitioner to claim the 6 pay or 7 pay now is already settled. That is the right of, that is the claim of the
But then
petitioner.
you say, see, just clarify on 2 things. We are basically finding it be quite confusing. You say that so far as the implementation of the pay commission is concerned, that is now mandatory on the part of the school if that recommendation is accepted by the central government. Now, school is bound to do it.
Yes.
Now, the issue of the fund deficiency comes. Okay. Now, then you say thereafter there was a amicable settlement. Now, if that means this settlement will override the decision of the court.
No. But therefore, the issue with regard to the rights of the petitioner under the CPC or whatever recommendation, that is already settled. Now, with regard to the proposed closing down of the school in view of the financial deficits, according to the authorities, there was a discussion, and the DG also granted some grant in it, excellent grant in it to the school management authority, and management also persuaded the petitioners to appreciate the difficulties.
Settlement,
so it is an internal settlement to overcome the financial crisis at that point of time.
That is okay at that point of time. And what is the situation now?
Now situation in Melbourne school is running as usual.
So yes, Mr. Singh,
and they are
just
denying the
clarify on one
secondary
thing.
payments.
Now, so far as submission of Mr. Sangresho is concerned,
Yes, ma'am.
so it appears that you are bound to implement the pay commission recommendation the moment it is accepted by the central government, isn't it? Do you dispute that?
Yes, my lord.
Okay, so that is not the correct position.
No, my lord. In fact, my lord, this is a private school run by a society.
But then, just a second, just a minute. Yeah. The submission was made that the same issue was raised before Guwahati High Court.
My lord.
And that was rejected by the division bench of Guwahati High Court, which order subsequently was upheld by the Supreme Court.
Yes, my lord, there are many submissions which were not put in that earlier litigations, my lord. Therefore, that order, my lord, that has to be treated as par and current, my lord. There are many issues, and even the recent judgment of the Honorable Supreme Court, it says when it is a matter of private educational institutions, the school cannot be bound, cannot be compelled to pay in terms of
then tell us, say, supposing if you lead us to take a different view, whether that view can override the view which is expressed by division bench of Guwahati High Court.
My lord, the entire matter has to be looked into fresh, my lord, because there were many.
Whatever it is, can this bench do it?
Yes, my lord, because Honorable Supreme
one thing
Court
may come that you may say that there is a decision by a different High Court that will not be binding. But then if it comes to, you see, a proposition of law,
my lord,
then see, irrespective of the fact which High Court pronounces it, that will be applicable everywhere.
Yes, my lord.
So which way, even if you are successful in making this court pass some order in your favor, whether that will override that Guwahati High Court's decision.
Yes, yes, of course, my lord. It is because, my lord, very recently in similar such cases, my lord, Honorable Supreme Court in 2024 July, if I am not wrong, my lord.
What are the decisions, please? Can you?
My lord, that
this will be, you will have to enlighten the court about these things.
My lord, the copy of the decision, my lord, I will have to take a print.
So this will be a kind of, you see, like you will be seeking the review of the decision of the.
We are only on point of law, my lord. Only on point of law, my lord. And when it comes to law, my lord, this honorable court can always appreciate the law, my lord.
This anyway, just give us those. Can you do? Are you ready with those?
My lord, today I will have difficulty in giving the judgments, my lord. I will make a
since the
compilation.
question of law has come, you will have to enlighten this court with regard to this.
Copy of the judgment is there.
Even if it is Mr. Singhan's submission is that the many of the things were not placed before the Guwahati High Court at that point of time.
Yes.
Now, if this court is to take into consideration all those points, and you say pass a fresh order, then at least which way we overcome that decision of the Guwahati High Court?
I'm ready, my lord. I'm ready.
Okay. Similar issue, my lord, has already been decided very recently, my lord. I will place that order, my lord.
Please, that will be
a jurisdiction issue, my lord. Jurisdiction issue.
Mr. H.L. Sangresho, Learned Senior Counsel, appearing for the petitioner. petitioners. How many petitioners are there?
My lord, here
The number of petitioners.
40, my lord.
My lord, petitioner, my lord, they need to probably correct the rate petitions, my lord, because there were many petitioners, my lord, who are not in service anymore.
Some of them, my lord,
They have to correct.
Then you have to
retirement
strike
few.
them out.
But I'll ascertain the few of them retired, who of them, my lord, to strike out their names.
Please file an application that can be done. Yes. Learned Council applying for the petitioners. And also Mr. N. Sinkan, Learned Council applying for the respondent number.
My lord, I am for the ARPS.
It would be, my lord,
2,
my friend would be
3, 4,
3 to 5.
5. 3 to 5.
Yes.
None appears for the respondent number 1.
I am agreeing on behalf of our Devnath.
Mr. Devnas is supposed to be here.
Actually, Lordship is engaged in some other matter.
So then which way or what would be his submission then? If you have to say that you are present there, then you have to say your version of the case then.
He is not here.
It should not be something like that. A person comes and appears, makes a prayer for adjournment and subsequently agrees for hearing and then he disappears when the matter comes up. This is not a reflection of good conduct by a lawyer. At least before this court would not take these things lightly. We'll make an observation about the conduct of the lawyer. Made a prayer for adjournment. The moment he realized that he did something wrong, he disappears from the court.
It is absolutely inappropriate. Let my esteemed colleague inform the needs.
What do you say? However, learned CJC was not available. At the hearing. Though Mr. So-and-so appeared on behalf of the CGC. Do not say though, just say Mr. So-and-so, learned CGC was not available at the hearing, then stop Mr. So-and-so. Just give a comma, however, Mr. So-and-so represented him at the hearing. After arguing the matter at some length, Mr. Sinkan, Learned Council appearing for the respondent of 4 to 5. Yes, prayed for grant of some time to place on record but these decisions are not regarding these things which you are going to place, not regarding the Assam Rifle School.
No,
that is
similarly situated.
That will come as a citation.
Yes, citation.
What is it? Praise for grant of some time to enable him to place some decisions which may be relevant for the purpose of proper adjudication of this matter. In a senior counsel applying for the petition has no objection. Prayer alert list after
2 weeks.
Item number 11.
Proceeding before the Guwahati High Court, Assam Rifles was a party.
Yes, yes.
Fine.
Now this is something, you see, like if you fail to take some stand before in that court, because since you were the party, it is not that you were not the party.
However, my lord.
Now, just one thing.
Yes.
This court is, see, like these are the question which is coming to the mind.
My lord.
Now you were a party before the Guwahati.
My lord.
Now again you are a party here. This
Yes.
court. Now which order will be? You are a party. It is not that the Guwahati High Court decision, you are not a party.
I was part
Had
of
it been the situation, then the difficulty would not have been like this. But then what happened that there and here, in both places you are the party.
Now,
Probably
my
you
lord,
should have done
only-
something to get that order.
Yes.
You know, like
Now, my lord,
interpret.
only question here, my lord, is on law, my lord. Now, if the law says it has to be done this way, whether this court is bound by that earlier order.
So long a judicial pronouncement remained, that is law.
Yes.
So we cannot say that is not the law.
Yes.
That is what. You may have a different view, you may not agree with the court of the court. See, like judicial order, you may find that.
No, my lord, in
it
terms
suffers
of
from
present
many-
development also, my lord, of the
So
recent.
that's only thing is that, say, like Mr. Sinkan, you have to say, because before round of litigation, which has been upheld, the decision whereof is upheld by the apex court, you were party there.
I was party, yes.
Yes. So how that order can be modified by this court? Now this is what, see, your decision has to deal with that thing, because just this is one thing that you are party there. If you say that that decision was not correct because certain things were not taken into consideration and it's par inferior, in such a case you should have sought modification of that order.
My lord, review was
Otherwise it
also
will be difficult
filed.
because you're a party there, and that order will bind you.
Now, my lord, in terms of recent development, my lord, in the field of law, in terms of recent judgment of the Honorable Supreme Court, in similar such cases, my lord, exactly similar, my lord, where private educational institutions was involved. So,
Is it the same institution?
my lord,
Is it the same institution involved in both round of litigation?
not the same institutions, my lord,
But then
similarly
here it is
situated.
the same institution. You have to find some law on that. See, rightly or wrongly, if a court passes judgment, that will be binding so long it stands.
Yes. Now,
So
my lord,
that is what the difficulty is.
if the order
See,
is wrong,
Kindly appreciate one thing. This court is repeatedly telling you.
my lord,
Just bear in mind that you were a party before the proceeding body.
yes, ma'am.
So how you overcome that binding, which
Yes.
is created by decision, that is what you have to place it.
Yes, my lord, will try to satisfy. Oblige.
11.
Yes, Mr. Pasha. Another question.
Another question.
You want all the affairs to be quashed.
No, this is not FIR, my lord.
This is for the
Aggrieved by my lord.
we're
He was
aggrieved
not
by an
discharged.
order passed by the additional district session judge, who has refused to discharge me of my from the instant case. So we've challenged that order before this court.
Yes. Tell us what is the
Now, so I'll take straight away to the FIR.
yes, please.
Page 10 is the translated copy of the FIR.
Page 10. Yes.
I'll just read your lord. We, the family members of so and so, resident of so and so, would like to inform you in connection with the incident within bracket murder related to Pandaplang shooting. He went missing from his house on 16 July so and so, along with a vehicle ML10C3104. He received a call from one unknown person. On receiving the call, he went out of the house without informing us, the family members. We tried calling him in the phone, but no one was picking up the phone. On 17/7/2022 at 3 p.m. we got to speak with one lady, namely Smiti Iba, who found the mobile phone of his brother from the road along with slippers, but she took only the mobile phone. We, the family, on receiving the call and after talking to Smiti Iba, who found his mobile phone, they went and informed the police outpost, which is located at Sorankam, at 9 p.m. on Sunday. Thereafter, along with police personnel, went to search him from the place where the mobile was found, but all in vain. On 18/7, along with police personnel, went and searched for him, and at the same place we found his dead body on the side of the road in Shalom Joy Road, Sorankam, Maunikar, 9 a.m. But the vehicle was still missing and untraceable. In this regard, we, the family member, request the court office to take stern action against unknown culprit and punish him as per section of law. So this set into motion an investigation, Your Lordship. I'll show the manner in which an investigation has been conducted. So the entire investigation has been on the basis of CDRs and only CDRs. Nothing has been relied upon.
It's called daily record.
Call detail records. So I'll first take Your Lordship to the charge sheet. I'll take to the relevant portion of the charge sheet, which is
It's what page?
charge sheet begins at page 14.
Yes.
But the relevant portion, I'll take Your Lordship to page 29.
Yes. 29.
29.
Yes.
Lordship, may I have under the heading of requisition submitted for CDR and CF of the following number as received?
12. Yes.
12. So here they've listed the victim name is Pandaplang shooting. Second person is I Love You Talang, an accused person. Third is Ramesh Dakhar, accused. And fourth is Mercy Muru, wife of accused person Jiving Matlian. That is the petitioner before this court. Now A, CDR analysis of victim Pandaplang shooting, number so and so. Lordship, the last paragraph. Analysis of the CDR of the victim reveals that one mobile number so and so suspected to be used by the accused person, later revealed to be used by I Love You. This is the main accused person, Your Lordship. Was communicating with the victim since 15/7 at 12:20 hours. Further analysis revealed that the victim was in close contact with his mobile phone till 11:06 hours of 17/7. Moreover, an analysis of the mobile tower as provided in the CDR is evident that the victim person got a call from suspect number so and so at 21:52:36 hours on 16/7, and tower of location the victim was at the point of time was showing Madan Rating Thalasken. However, after receipt of the suspect phone call, the location of the victim shifted to the village Nartiang on 16/7 after the suspect number again called the victim. At 11:06 hours 17/7/2022, the location of the victim, while again answering the call from the suspect, shows village, which approximately location of the place where the body of the victim was recovered. So there was one phone number, which is this 8798177121, which is being used by the main accused person I Love You. Now this phone number was sent for CDR, and the extract has been given at B, the next page, or the next paragraph. Analysis of CDR and CF of suspect number so and so used by I Love You Talang. Now if we see the name of the subscriber, Your Lordship, is Janisha Shadab. So we're not concerned with that. Maybe he has misused a mobile phone of another person, but we're not concerned with that. If you see the analysis of CDR, the suspect number revealed that, Your Lordship has that after the statement of Janisha Shadab.
Analysis of the CDR.
Suspect number revealed that.
Yes.
IMA of the phone used by suspect I love you Talang is so and so. The number was in contact with the phone number so and so. This is the number of the victim on following occasion 16/7 and 17/7. Outgoing call so and so, incoming call so and so, incoming call on 17/7. It may be noted as per CR analysis of the tower location of so and so by use by I love you Talang reveals that the accused person was present in the area around Umulang, West Hill up to 19:45 hours on 16/7. I love you Talang then started to move to Sorangkam on 17/7, which reveals that the accused person had travelled from Umulang towards Sorangkam on the night of 16/7 and places him within the vicinity of the place of occurrence where the body of the victim was recovered, as well during which the period in which there was a telephonic exchange between the victim and I love you Talang. So they're saying during the time of occurrence, that is on 16/7, the tower location revealed that he was in around the place of occurrence and he had also contacted the deceased person Pendaplang shooting.
But then you are not nowhere in the picture till now.
No, till now I'm not there. Next page, Your Lordship, at page 31.
Yes.
That as per the CDR analysis, tower location reveals that on 17 the accused person was around Pomleher area.
You're reading from
page 31, the first line.
First line, yes. Okay.
Pomleher area on 17. The location of Alifio Talang was showing around Kletrshi. As per the CR analysis of tower location number used by so and so, the accused person was in Kachar district of Assam on 17 from 5:30 to 19:47 hours. Hence, it is evident that on the night of 16/7, the following morning on 17/7, the deceased person so and so moved from West Jaintia Hills towards Sorangkam area and later proceeded to Kachar district and later in the evening returned back to Meghalaya. Now, C is the analysis of another accused person named Ramesh Dakhar. Now, they are saying that this Ramesh Dakhar had contacted the main accused person, that is I love you. So they have extracted this call detail records.
Where you are coming into picture?
I will come after this, Your Lordship.
You have to grow a climax and then take us to the conclusion.
Yes, Lordship.
Yes.
So, Your Lordship, C, I'll not read all this, CAF and all, Your Lordship. I'll come directly. CDR analysis of suspect number revealed that. Your Lordship has it?
Yes, down below.
Yes. That he was using phone number so and so. I may connected to number so and so. That between 16/7 and 18/7 he was in contact with a deceased accused person I love you Talang phone number on several occasions. It clear evident from the CR analysis that the phone number of accused person Ramesh Dakhar, that on the night 16/7 and early morning 17/7 he was moving from West Jaintia Hills and thereafter proceeded to Kalyan area of Kachar district, Assam, in the morning of 17/7. Then he again entered Meghalaya at Ratachera on the night of 17/7 about 20:45 hours. An extract of the CDR revealed that on 16/7 at 18:43 he was in the vicinity of village Mokla, PO, West Jaintia Hills. On 16/7 he was in the vicinity of Mukundur Umulong, West Jaintia Hills. C. On 16/7 he was in the vicinity of Puriang, East Khasi Hills. 16/7, 21:23 he was in the vicinity of Mauringkeneng. On 16/7, 21:55 hours he was in the vicinity of Pamlahir. On 17:65 he was in the vicinity of Dakral, PS Katikar district, Kachar. On 17 he was in the vicinity of the village Ratachera, East Jaintia Hills district. So even his tower location shows that he was in around the place of occurrence and he was in contact with the main accused person during that time of occurrence. Now D, Your Lordship, is the CDR analysis of my wife. Admitted possession is I do not possess a phone. So what they have done is taken out the CDR analysis of my wife's phone number. Even the name of the subscriber is not though of my wife, Your Lordship. His name of subscriber is some Karimun Nessa. Now I'll just read the analysis of the CDR. Your Lordship has that right after the details. The phone number is connected with IMI so and so. That I love you Talang had communicated stated on this number prior and during the commission of the said offence. 14/7 at 17:01 hours and 17/7 at 13:04
After the
41
incident.
hours after. So it was nowhere during a time of place of occurrence, nor was the tower location.
But then it is
Yeah.
before and after.
Yes.
That is what it says.
Now,
Yes.
this was corroborated by the next paragraph, which is apparently a statement of my wife. If I may just read the statement. She stated that during Minthiang as her husband and stayed together in Mubakhan village, Nartiang, and having 3 children. She is the housewife, but sometimes used to help her husband by going into cultivation and their own farming field. She further stated that the mobile phone so and so belonged to her and she bought it by herself, but her husband Jiwing does not have his own mobile phone, and whenever her husband required to contact his relatives or friends, he used to ask her mobile phone for contacting them, but she had no idea that her husband misused her mobile to receive or call late I love you Talang for committing crimes. She further added that her husband did not take any phone with him on 16/7/2022 when he left home, and since he did not return home on the night of 16/7, she had called on the number of I love you Talang on 17/7 at 13:04 to inquire about her husband, since she knew he had gone with him. She added that she was unable to talk to the accused person during Mantliang and told that he would return home in the evening. So apparently the main accused person had told the wife that he was with him during that period of 17/7. Now, Your Lordship, even the trial court below, while I had argued for discharge, had relied on this statement along with that CDR which has been extracted. Now, Your Lordship is well aware that a settled law, firstly, the CDR is not a substantial piece of evidence, but it has to be corroborated by further evidence, which is on record. So their corroborative piece of evidence is apparently the statement mentioned here, reproduced at 13.
How can we foresee what will be corroborating evidence?
Yes, Lordship.
That corroborative evidence may be laid by different way.
Yes, Lordship.
Even when IO is examined, he may come up with some other evidence.
Yes, Your Lordship. So the along with the CDR, they have stated that my wife had called the main accused person and stated that I was present with the main accused person at the time on 17/7, not at the time of occurrence. Now, Your Lordship, my argument is on this basis. To proceed for trial, Lordship, the trial court had to look into the materials on record, that is the charge sheet, and could not have looked beyond it. So apparently this statement which is reproduced is not a statement under 161. All other witnesses, Your Lordship, statement under 161, there's a separate and distinct copy attached in the charge sheet.
The statement has been taken in which form, in what manner, that is for the prosecution to explain, and that will be explained at the time of the trial. We cannot see or tell of these things that it should be taken as a separate sheet.
Your Lordship, you just have
because you understand that before statement, before police officer is not required to be signed. So it can be in any form.
Lordship may just have section 161 of CRPC.
Please read it. Read it, please. Read it.
I'll just read, Your Lordship. Examination of witness by police.
Yes, please. Go ahead, go ahead. No problem.
Okay, Lordship, 161(1) provides any police officer making an investigation on this chapter or any police officer not below that such ranks as in the state government by general or special order prescribed in this behalf, acting on the requisition of such officer, may examine orally any person supposed to be acquainted with the facts and circumstances of the case. 2. Such person shall be bound to answer truly all questions relating to such case put to him by such officer other than the question to answer to which would have a tendency to expose. 3. The more important, Your Lordship, the police officer may reduce into writing any statement made to him in the course of an examination under this section, and if he does so, he shall make separate and true record of statement of each such person whose statement he records.
Yes. So,
Your Lordship, if you see, this is not.
Which way? See what it says. The police officer may reduce into writing. So he may or may not.
Yes, Lordship, but this has been reduced to writing.
Statement has not been reduced in writing.
Lordship, in my submission.
Doesn't mean that you have not given any statement. So that is what.
Lordship, my submission is that he has reduced to writing, but this is neither a separate or distinct.
No. Which one he has reduced to writing?
Para 13, Your Lordship, of page 32.
Yes.
It's merely a reproduction of a statement. Your Lordship, if you see other statement under 161 is there.
How do you say it is reproductive of a statement?
Because it's not
See,
under
see,
the
161 sub clause 3, which you have read out just now. What does it say? The police officer may reduce, may reduce. And if in case he reduces, then a separate sheet may be attached. That is what, isn't it?
Yes, Lord.
So if it is not reduced in writing, then no need of enclosing separate sheet. And different witness can be examined in different way. For one witness, it can be reduced in writing. For another, it may not be.
Sure, but
it should be enough. It is reflected in the CDL.
The entire charge sheet that is against
sorry,
me, the entire charge sheet that is against me, particularly is on this statement itself of my wife.
That's all right.
And that plays a very important role.
If it is accepted, then there may be some charges against you. If you argue that even this statement is accepted as correct, then you cannot be held guilty. That will be different. But then it doesn't seem so.
Or you should, even the statement made by my wife does not show me at the time of the place of occurrence that I was even there. Statement of my wife says that on 17/7 I was there, not on 16/7.
This you can understand, Mr. Pasab. You are able man. You can understand to what extent we can go.
I understand it.
Till now, we have not even made out a case which makes a court to ask the other side to clarify. Normally, these things will not take a different view other than what has been taken by the trial court. Until and unless you can show that the view taken by the trial court is absurd and it is not at all basically possible on the basis of this. You have to come with a better preparation or better point. What is the impugn order, Mr. Pasa?
It begins at page 151. And the operative portion is at 154, the last para.
It starts from
151.
Yes, we are 154. We are at page 154.
154, the last para, Your Lordship, is written as pursued the material on record. That's the operative portion of the judgment.
You are viewing my thing, is it?
Viewing with you.
That is, see, you were not there at home also on the
on 16/7. I was not there.
So that is good enough. You see, what is
the only allegation is made is that upon a phone call I was with the main accused person on 17/7. That is not the date of the occurrence.
It's okay, but then you see, many things may be revealed. You see, what we are concerned at this stage, that whether there is a prima facie material to connect you with the commission society. The further elaboration will take place during the trial.
Because even so the CDR, Your Lordship, 2 calls were made. One on 14, which is not the date of occurrence, and one on 17. That also not the date of occurrence.
Before and after, that is what the charge sheet says.
Yes, Your Lordship.
So what plan was there in your mind? That will be revealed. Let the evidence reveal.
So, Lordship, for the other accused person, there is, even though even limited, there is something to proceed for trial, Lordship. In my case, there's absolutely nothing.
This is good enough that you were in touch with the main accused before and after.
Before.
And on the day of the occurrence, you were not at home. Good enough. You would try on some other day. We want the court to pass the order now. We can pass the order also if you want.
We can pass because, anyways, Your Lordship, the trial has been proceeding for quite some time.
Charge has been framed.
Charge has been framed. Evidence has started, Your Lordship.
Yes, Mr. Guru. Anything you want to add?
My lord, I think.
Okay. Heard, Mr. Here, Pasa, Learned Counsel. Appearing for the petitioner and also Mr. Guru. Who is appearing for sworn number 2?
We've affected notice upon them, but none has appeared.
Okay. It was served. Sworn number 2 is the
complaint.
And Mr. Guru. Learned GA. You are still GA, Mr. Rod. You are not additional P or anything.
I'm still GA, my lord.
GA. Appearing for the response number 1. Stop. None appears for the response number 2. Sit down, sit down. By this revision petition, come on. The petitioner has challenged the order dated 5/6/2024, passed in session case number 1T of 2024, by which the learned trial court had directed framing of charge against the petitioner under section 120B 120-V stroke 302 stroke 201 stroke 34 IPC. Stop. The fact of the case is that an FIR dated 19/7/2023 was lodged by the response number 2 before the officer in charge, Soringham Police Station, East Kasil District, Meghalaya, stating that
It's not Sorangham, it's Mortanian.
is it? But then that is mentioned here in his synopsis as Soringham.
Page 10, my lord. FIR.
No, but then synopsis is given for the. Okay. The officer in charge Soringham not there. Just write it. The officer in charge Marinkanang PS East Kasil this. Page 10 of the petition. Okay.
Because strangely in page 9, whereas the original copy is dated as Soringham, Your Lordship. Page 10 is translated by the police itself.
See, Mr. Gurum.
Yes,
see, this typing error. See, you should be careful.
It's typed by the police
it
itself.
was received there and forwarded to, it is in the bottom, it is noted there.
So then FIR is lodged with the Soringham police
It
station.
should be Soringham.
Is there any Soringham police station?
Yes.
There is.
Or
It's an
there is no
outpost.
Outpost. Hence it was forwarded to the PS.
Much was lost before the officer in charge Soringham police outpost. You just said. Informing that one late Pindaplang shooting So what you said? Informing about the disappearance of one late Contempt shooting since 16/7/22 and discovery of the body of this said person on 18/7/2022 from a drain at Shillong Joy Road, Soringham, Mauclair. Stop. On the basis of the FIR, the Marankanang PS case number 21/7 of 2022 under section 302/201/34 IPC was registered and investigated into. Stop. Upon completion of the investigation, the charge sheet was prepared and forwarded to the learned trial court. Seeking trial of the accused's name in the charge sheet. Seeking trial of the accused person's name in the charge sheet. The petitioner has prayed for his discharge before the trial court, as according to him, no prima facie case was made out, and the trial could not have proceeded against him. Stop. However, the learned trial court, by impugned order 5/6/2024, rejected the prayer of discharge made by the petitioner and directed for framing of charges against him. Stop. Assailing the order dated 5/6/2024, the petitioner has preferred this revision application. Assailing the order dated so and so, the petitioner has preferred this revision application before this court. If there is any repetition, you will omit it. Yes. Mr. Pasa, Learned Counsel for the petitioner, drawing the attention of this court to the contents of the FIR as well as the details of investigation in the charge sheet. has submitted that the entire prosecution case is based on circumstantial evidence collected during the course of the investigation. And a scrutiny of those circumstantial evidence does not make out any case against the petitioner. It is a submission of the learned counsel. That the prosecution has shown involvement of the petitioner. Basic one. What do you call it? Call
detailed records.
Call detailed records analysis. Of the phone number of the wife of the petitioner. Which according to the learned counsel does not make out any case against the petitioner, as the details which has been reflected in the charge sheet as the details of record, as the call details of the phone number of his wife reflected in the charge sheet does not anyway implicate him in the case. But the learned counsel has submitted that analysis of the CDR. When you first write the collated records, in the bracket you write CDR. The learned counsel submits. The analysis of CDR would show that the main accused in the case had communicated to the number of his wife once on 14/7/2022 and again on 17/7/2022. Whereas the date of incident alleged by the prosecution is on 16/7/2022. He submits that the revelation of details as made in by the details of CDR in the charge sheet is not good enough to make the petitioner to face a trial, to go through the rigor of trial and praise for setting aside of the impugned order and discharge of the petitioner from the liability of the case. Here paragraph. Mr. Guru Nanak GA on the other hand has objected has refuted the submission made by the learned counsel for the petitioner and submitted that enough materials is provided in the charge sheet to make out a prima facie case against the petitioner. Stop. He submits that the London Trial Court has taken into consideration all the relevant details of evidence, the relevant details of allegation appearing against the petitioner in the charge sheet and has rightfully passed the order which requires no interference. Has rightfully passed the order, give a comma, then you say which requires no interference by this court. Paragraph. Upon hearing the learned counsel for the parties and the perusal of materials of record would indicate that the charge sheet in the session case number 1T of 2024 has indeed been filed against the petitioner basing on the circumstantial evidence collected from the CDR of different mobile numbers the from the analysis of the details, CDR details indicated in the charge sheet, it appears that Srimati Mercy Muru, the wife of the petitioner, was using a mobile phone service of which used to be availed by the petitioner also sometimes. Depending on needs, dependent on needs. The details of the call details of the said mobile phone indicates that the, that calls were made to the phone number of the prime accused before and after the incident alleged in the FIR. Stop. Furthermore, it appears from the perusal of the statement, perusal of the charge sheet that the petitioner was not at home. What is it? Further it? No, it appears from the statement of the wife of the petitioner as reflected in the charge sheet that the petitioner was not available at home on the day of the alleged incident. Give a paragraph, then is a perusal of the impute order would indicate that the learned trial court had taken into consideration the relevant part of the charge sheet while rejecting the prayer of the petitioner to discharge him from the liability of the case. The see, your wife has disclosed that you went out with Mr.
Correct.
the main accused. So that makes things more worse against you. Correct. There is a clear indication just tell me the last bit. This court also does not see any reason to take a different view from what has been different view other than what has been taken by the trial court. Especially in the light of the statement of the wife of the accused appear in the charge sheet, which indicate the petitioner had went out with the main accused at the time, at around the time when the incident took place. Give a paragraph. The taking into consideration the materials on record as discussed above and the gravity of the crime involved, this court finds the contention of the petitioner not acceptable, and as a result this criminal revision stands dismissed. There may be some correction here, there may be repetition of something, so we'll just correct it.
So even the miscases data may be disposed.
Miscuse, okay. Miscuse also in view of the record. Yes.
Item number 80.